Thank you for your patience, Mr. Zellerman.
Thank you.
I started off today with bad technical trouble, so I'm sympathetic.
I was a witness to that.
Well, there he is.
Testing 1, 2, 3. Can you hear me?
You're cooking with gas now, Mr. Smoker.
Thank you, Your Honor. I apologize for the glitch.
Hey, you know, I was there earlier today, so okay, start whenever you want.
Thank you, Your Honor. May it please the court. I'm Dave Smolker with the Smolker Matthews Law Firm. We're here on behalf of the appellants Sally Diener and Victor Randolph. I would like to reserve the balance of my time, if I might.
Generally like to keep that around 5 minutes, so, you know, thereabouts.
Okay. Thank you, Your Honor. Your Honors, this is really a classic example of where the court's equitable powers should be invoked to resolve what would otherwise be a somewhat legally intractable problem. And by engaging in equitable powers, I think we can achieve justice for both sides. The facts in this case are essentially undisputed. In 2013, the Diener's predecessor entered into an easement agreement, and it provided, I quote, "The owners of parcel A1, which is Mr. Zeller's residence, shall have unrestricted access across this easement for ingress and egress and for the placement of subsurface utility lines," and this is important, "if necessary." Now, the western portion of this easement is located on the Diener's property, and it's separated by a wall from the eastern portion where the driveway and the utilities were located. It's undisputed that the purpose of the easement has been satisfied. There's no need for the use of the western portion to provide ingress and egress or utilities. The Diener's unencumbered use of the area west of the wall will not interfere with the Zeller's use of the property. The reason that we understand the Zellers are concerned is that if the width of the easement is reduced below 50 feet, it creates a potential nonconformity with the City of Tarpon Springs code, which requires 50 feet for a local street width. And I think that concern is understandable when it comes time to sell property. Potential purchaser.
Let me ask you a question.
Yes, sir.
Number one is that my records indicate that there was no transcript in the record of the final hearing with the judge.
I think that may be the case, Your Honor.
Okay. Second, that this appeal concerns only count 2 for the declaratory judgment, not count 1 for reformation.
That is correct, Your Honor.
And then number 3 question I have down here is, what is the specific relief that's being requested?
Yes, and I'm basically quoting you from what we had requested in our complaint in our summary judgment motion. And what we asked for was that the portion of the plaintiff's property lying west of the retaining wall neither interferes with nor is necessary for the purposes of the easement, to wit, to provide defendants with access to and from their property and to provide utilities to serve their property. And then the second request was that the court conclude that the plaintiffs would be entitled to make lawful unencumbered use of the portion of their property lying west of the retaining wall, free from any interference by the defendants, as if the easement did not encumber that area, except for purposes of a width of 50 feet to satisfy the city's requirements. And if you were to enter a judgment to that effect, it could be recorded in the official records. And I think it should resolve both of the parties' concerns. The width would technically remain 50 feet, and the Dieners would have unencumbered use of the area west of the wall. And the reason for this 50-foot requirement is really sort of somewhat anomalous. It's a result of the City of Tarpon Springs code that says if you're going to subdivide property into lots, you have to comply with their subdivision regulations. And their subdivision regulations require that you have a local street, and a local street has to be 50 feet in width. But the practical reality on the ground here is that 50 feet was not necessary to provide ingress and egress and utilities to the Zeller's property. As a practical matter, the area was easily accommodated in less than 50 feet. And as another,
Smoker,
yes,
so I understand what you're saying is you want to basically get a declaratory judgment canceling in effect the easement, or at the very least revising the modifying the easement. But if I look at the easement, it says it's perpetual. I don't see where it's modifiable, unless you can correct me if I'm wrong. And then as far as the 50-foot width for the driveway, I think I know where the I think it's the Board of Adjustment, their findings of facts. When the Diener went for a variance, I guess, for the reduction on the setbacks for the rear and the side, I think they, in findings of fact number 2, reiterate that the subdivision includes a 50-foot easement as required by the city's subdivision standards. So I'm not seeing where in the law is it allowed for the Dieners to do what they want to do here and modifying the easement.
well, I think Judge Smith, the answer is that it doesn't lie on the law side. This lies on the equity side.
I understand that, but we would have to disregard the language of the easement agreement, would we not?
I don't think so, because again, the easement agreement says that the owners of parcel A1 shall have unrestricted access across this easement for ingress and egress and for placement of subsurface utility lines if necessary. It's undisputed in this record that it's not necessary to utilize the area west of the wall that encumbers the Diener's property. And so we're relying on equitable principles, which underscore and underlie the whole purpose of declaratory relief. The Kingdon case, which is the second DCA case that we cited in our brief, 156 Southern 2nd, 208 at page 211, states that declaratory judgment is largely equitable in nature, reserving the fullest liberty in molding decrees to the necessities of the occasion in easement and servitude cases. And I think that principle applies here. I don't think we have a case that's precisely on point, but as a practical matter, it's not necessary anymore for the Dieners to be able to, I'm sorry, for the Zellers to use that area that's west of the wall. And what we were proposing is not to cancel the easement, is to just essentially modify it based on equitable grounds and preserving the width of the easement in order to ensure that the city's 50-foot requirement is still technically being met, as a matter of law. I think what
would happen, I guess, because you bring up the utility issue, if there was new construction that additional utilities needed to be brought in?
Yes, and that's a fair question. And the reality here is that this particular local street 50-foot wide easement is really only serving 2 lots. It dead ends at the Zeller's property. And so it's highly unlikely that there would ever be additional lots that would have to be serviced, additional utilities that would have to be installed or constructed. So, in terms of the actual reality, I guess I'll refer to the necessities of the occasion in the easement, as the Kingdon case refers to. It just is not likely that that's ever going to be an issue.
But the easement itself does not permit or allow easements to be changes.
No, it doesn't. But again, part of the issue is we're not on the law side. So we're not analyzing this easement for purposes of what it says specifically about whether it can be modified or not, because the court's equitable jurisdiction allows it to fix what would otherwise be an intractable problem from a legal standpoint. So equity is trying to fill the void, really to do the right thing under the circumstances. And I don't think
But don't the facts here weigh against your equitable argument, where I believe your clients were living at the property and were aware of the easement before they purchased the property?
Judge Smith, I think that's a fact, that it does weigh against our clients. However, I don't think it's sufficient to outweigh the equities that are the larger equities that are associated specifically with the language of the easement. In other words, if it's
Well,
not,
did the easement prohibit them from expanding their property for a garage when they sought a variance?
no, it didn't. What happened with the variance, Your Honor, was because the 50-foot right-of-way encumbered their property, when they wanted to add a carport, they had to then contend with this new easement line, and they couldn't otherwise meet the setback requirement. So in other words, this 50-foot width issue is sort of compounds the difficulty that the Deaners have in actually being able to utilize and potentially expand their property. So
Okay, and so they were able to do that. So when you talk about use of enjoyment that they're not able to do, can you give me an example of what you're talking about then? Because I mean, if they were able to obtain a variance from the county to, increase their garage area or add a garage, what kind of use and enjoyment are you talking about?
well, I think as a practical matter, they can still use that area. However, I think that the existence of that easement encumbers and to a certain extent clouds the title of the property. And so in the final analysis here, what we really have is we have a square peg in a round hole. We had a city.
I know, but I know, but help me out how they were aware of this when they purchased it. I mean, this is a recorded easement. So how does that play into what your argument is?
I think what you're suggesting is that maybe there's an estoppel here because they knew or should have known. However, I don't think that that fact in and of itself is sufficient to overwhelm the strong equities there. And I would point out, and we did cite this case in our brief. I can find it for you. You'll bear with me for a second. There is the, I believe it's Klein v. Bernardsville Association Inc. case, which is an out-of-state case, admittedly, but we really don't have Florida cases that really drill down on this precise issue of the notice. And there, if I might find the exact wording. We also cite to the restatement of easements, which talks in terms of similar equitable authority on the part of the courts. And yeah, actually, it's the Stewart v. Compton case. 549 Southwest 2nd, 832, 833. Kentucky Court of Appeals case in 1977. There, the court allowed a change in an easement location where the owner of the servient estate and this is important, who purchased the estate with knowledge of the easement, neither changed its purpose nor materially inconvenienced the dominant estate holder. So in this particular instance, that precedent weighs in our favor, because in this case, it's undisputed that I'll call it the equitable reformation of the easement that we're seeking neither changed its purpose nor materially inconvenienced the dominant estate holder. So we would suggest to you here that we've cited out-of-state cases that I think are on point. We do have the second DCA decision in Kingdon. Another case that I think is germane is the Dama v. Bay Bank case, which is 56 Southern 3rd 827. It's a fourth DCA case. And there, the court said that where the intent of the parties was not to create an easement for ingress and egress over the entirety of a specific piece of land, but to limit the scope of that easement to only the portion necessary to the purpose of the easement, which is what we have here. The courts will grant equitable relief in favor of a servient estate's entitlement to unencumbered use of the unnecessary portion of the easement.
Okay, Mr. Smoker, you were at 15 minutes in. If you want to, you have 5 left, so use them as you wish.
Okay, very good. We would suggest here that you should reverse the circuit court's grant of summary judgment in favor of the Zellers. We've pointed out the procedural problems that existed in that regard, which was that the Zellers never even addressed the issue in their motion and then never responded to ours, and that on count 2, and that secondly, you should reverse the denial of our summary judgment on the grounds that the facts, undisputed facts, establish a just circumstance for invoking equitable powers of the court. And since you are on de novo review, you are free to reverse the trial court on those grounds, and I'll reserve the balance.
You have 4 minutes left. Okay, Mr. Zeller.
May it please the court, I'm Christian Zeller. I represent Appalese, and together with my wife, Ines Zeller, I am the defendant, respondent, and appellee in this matter. Mr. Smolka asserts that there are no Florida cases with respect to notice when it comes to easement. I think that this court by itself has held numerous times that there is notice and that it will enforce restricted covenants against those who have notice. The latest case on that is actually Davis v. Veranda Lake Grady, decided by this very court on January 13th of 2023, specifically says courts will enforce restrictive covenants against those who have notice of it. And here we certainly have a restrictive covenant. And I'd also like to address Judge Case's issue not having a transcript of the trial proceedings. As an alternative, Judge Case, if I may refer you to the actual judgment, to the actual order of the lower court. It's in the record on 134, starting at page 639. And I truly believe that that is instructive for the court, because it specifically addresses the facts. In this case, it's instructive actually for 2 reasons. Not only does it address the facts in this case, it also includes the perpetual easement and maintenance agreement. It includes the survey, and it includes the legal description. But I think most importantly, this order is actually a joint draft by opposing counsel and myself. And if opposing counsel would not have agreed with the wording and the attachments to this order, they could have drafted a competing order. And then, of course, the lower court could have made a decision on how to go about that. But they did not. Further to Mr. Smolka's assertion that, about this Kentucky case, that an easement can be relocated. Of course it can be, but it'll still be 50 feet wide. It'll still have to fulfill the same purposes as in this agreement. We just move it any other place. And the restatement in itself does allude to that as well. But I think what is most instructive here is the Diefendorfer v. Forest Lakes case from the 5th DCA here in Florida, 1992 decision, which clearly talks about the scope and the necessity on how an easement has been created. Here, this is very clear how the easement has been created. There was a condition precedent by the city of Tarpon Springs that if this property were to be subdivided to make one property into two, there had to be a 50 feet wide ingress egress right of way. And that's exactly what the grantors did. And they did so by creating a perpetual easement and maintenance agreement, which describes specifically the terms of that agreement. In addition, Diefendorfer also says that speculation as to what is actually necessary for myself and my wife to have ingress and egress to the property is completely irrelevant. It's the terms of the easement that matters. But in an effort to satisfy Mr. Smolker on that, if we go back to the order in and of itself clearly says that my wife and I are driving on what's called the cross-hatched section of the specific purpose survey. So this does not encompass the entire 50 feet. It actually says where we are driving. This is also in the perpetual easement agreement. It specifically says where the driving portion within the easement is. In addition, Diefendorfer says that if there were any ambiguity in the agreement, which I don't believe there is, then it would have to be resolved against the grantors. But most importantly, and that's what Diefendorfer says, this court does not have the authority to rewrite an express grant. And clearly what we have here is an express grant. And this court has held so in Hagen v. Sable Palms, Florida 2nd DCA 1966. It has also held so in Shadow W Apartments v. Department of Transportation, Florida 2nd DCA 1986. It held so in Hillsborough County v. Kortum, Florida 2nd DCA 1991. And it held so just recently again in SHM Cape Harbor v. Real Mark Meta, again, Florida 2nd DCA 2022. And again, I'll go back to Davis v. Veranda Lake v. Grady, the latest decision of this court that it will enforce restricted covenants against those who have notice. The Randalls had over 1 year notice of this restriction. They lived on the property on a lease with an option to buy for over 1 year before they purchased the property. So for them to say they didn't have notice or they didn't know what those restrictions were is not appropriate. And unless the court has any additional questions with respect to these easement restrictions, I'll rest on my statements today and my brief, and I would respectfully request that this court affirm the decision of the lower court.
Thank you, Mr. Zeller.
Thank you, Mr. Zeller.
Mr. Smolka.
Thank you, Your Honors. A couple of points. First of all, on the notice issue, the language of the easement itself refers to unrestricted if necessary. That's putting a person on notice that there is a qualification to this easement that's based on necessity. And it's undisputed that use of the area west of the wall is not necessary. So the fact that our clients purchased with knowledge of the easement, a reasonable person would look at that language and conclude that if it's not necessary to the purposes of the easement, then they should be able at some point along the way to seek some kind of equitable modification of that easement. So the notice issue, I think, is on the law side. I think on the equity side, the language of the easement really pretty much negates the idea that our clients somehow don't have equities with respect to the notice. The easement itself put them on notice that it was only to the extent necessary. Now, I think Mr. Zeller's arguments in his brief and below before the trial court are all on the law side. In other words, yes, legally, if you apply legal principles, established legal principles of construing easements, then yes, he's right. But we're not on the law side here, okay? We're on the equity side. And the equity's purpose is to fill voids in the law when justice requires. And this is a classic example of where justice requires that the court exercise its equitable powers. And I think that the trial court, I think, and it's, you know, it's easy to do, but there's a big difference between the law side and the equity side. Our count 2 was seeking declaratory relief based on equitable principles. And I think here the equitable principles weigh heavily in our favor. And I think the trial court erred in not giving them the credit that they were due. And, you know, I think in closing, what I would say is the law, we shouldn't abandon common sense. The law should not abandon common sense. And I think that's the whole purpose of equity, is to sort of cure this unusual situation where the city of Tarpon Springs basically treated what amounts to a driveway as if it was a local street and required an easement as a condition of being able to subdivide the property. So we would ask that you reverse the trial court with respect to its grant of the Zeller summary judgment, and reverse the trial court with respect to its denial of the Diener's summary judgment, and either simply grant us summary judgment because the facts are not at issue, or remand back with instructions to the trial court to go ahead and enter judgment in our favor. Thank you.
Thank you, Mr. Smoker.
Thank you both. In order to leave our virtual courtroom, you need to click the leave button on your Zoom screen, and you'll be off in the ether and we'll be finished with you. Okay, that's our last case of the day. So we are adjourned.